the High Court has to ensure that the substantive justice is done, just like we are enjoined by Article 126(2) of the Constitution. That cannot happen, Your Honor, if you continue with the proceedings that the Constitution wants to bring to bear without giving High Court a chance to look at the record of today and entertain our technical and legal objection to the way that this court has, although it is obliged, calculated the remand period, refused. That's one of the issues which are being taken there. So one of the questions for High Court is a magistrate empowered to decline calculate remand date from 20th November last year to date? Is the magistrate legally in law, not in caprice? Is a magistrate in law, not caprice, entitled to decline to calculate, to count mathematically the days that an accused person or accused person has spent on remand? Our opinion is that is legally unconstitutional from that magistrate. We want the High Court to intervene, and it cannot intervene unless this court allows it. Because the point of mandatory bail, Your Honor, I would like to be understood. Your Honor, the point of mandatory bail is to ensure the personal liberty of the accused. It is not something made perfectly. It is made so that life and meaning is given to the presumption of innocence, among other reasons. So this is a matter concerning fundamental human rights and freedoms of the accused person. So in making this application, pursuant to the provisions, my land coding article and section 17 of the Education Act and the other provisions, is that we are trying to go to High Court to cry out to the High Court and say that the person the bail guidance told to calculate days has refused, and has said so in writing that I have not counted the days. What is stopping her? The state will explain. Why is she refusing to count the days of remand? Yet the law does not even give her the option not to. Those are some of the questions we will be taking. Thank you very much. These are very serious matters. First of all, I think my land brother misunderstood the scope of our application. It's not just a revision application. This is also an application for supervision. And as I carefully said, but failed here, it also brings on section 17 of the Judicature Act. Your Honor, logically, it will serve no purpose for us to proceed to the High Court if you proceed with today's proceedings by the prayers of the Constitution. In other words, you will be indirectly telling us that we don't go to High Court, because there will be no purpose of going to High Court if you are going to be a committal proceeding. It is both illogical but also legally unconscionable to entertain committal proceeding whose net effect is to frustrate the mandatory bail of accused person. In law, it is called abuse of the process of law. If a magistrate conducts court in such a way that when the prosecution senses that the mandatory bail application has been triggered or is looming, to ensure that there is a committal so that the accused persons do not successfully apply for mandatory bail, that is an abuse of the legal process. It is important that we be mindful of the context of this pre-trial proceeding. The accused here were not arrested in Uganda, were abducted, tortured, illegally detained in a military detention for 4 days before they were arraigned before a kangaroo military tribunal. Can I proceed? Please. Maybe the court can say that. Yes, I'm not raising issues. So Article 43 of the Constitution, and in the context that I've said, forbids political persecution. What we are seeing here, the use of committal proceedings to stop mandatory bail is a stellar example of political persecution, which is prohibited in absolute terms by Article 43 of the 1995 Constitution. A prosecutor is precluded from using his office to initiate committal proceedings so as to forestall mandatory bail. This is my opinion. I think you are not going to zip my mouth.
Just a minute, Your Worship. You see, Counsel, I don't want to take about terrorists. Because it's what we call, we need to proceed in a manner that actually represents what was done. If you hold up with the lawyer, then present your facts and evidence as a lawyer. You cannot submit in this court and attack the office of the DPG that they are coming up here. What do you and you say that the office of the DPG prepared committal papers in a bid denies the applicant from benefiting from mandatory bail. You do have an agreement with you? We are performing our role as DPG. So there are some things, yes, there are some things that shouldn't be said here. Otherwise they become too unprofessional and courteous.
Yes, I'm finishing. Section 5, Clause 5 of Article 120 on the power on the Office of the Director of Public Prosecution reads as follows: that in exercising his or her powers under this article, the Director of Public Prosecution shall have regard to public interest of the administration of justice, and the need to prevent the abuse of the legal process. What are we seeing here, Your Worship? A classic example of the abuse of the legal process by the Office of the Director of Public Prosecution, in his words, claiming that they have come with the committal papers so as, in my opinion, and the opinion shared by the entire legal team and the accused persons here, to frustrate mandatory bail. We implore this honorable court to prevent that abuse of legal process, because it is also tantamount to political persecution prohibited in absolute terms by Article 43 of the Constitution. We cannot run away from the context of this matter. Thank you.